All right, welcome everyone. It's another Friday, so that means free webinar Friday. Well, attorney, founder of Dana and Associates. We practice estate planning and probate in Arizona and California, and the founder of Mott Legal, which is our brand of estate planning that we're going to be bringing to other attorneys soon. So stay tuned, attorneys, for more from Mott Legal about our app and our specific digital asset planning processes that we'll be opening up to let other attorneys practice in that. So today, first off, let's see. I want to welcome our new attorney. Let's get her into the stream. Welcome, Barbara.
Thank you. Hello, everyone.
So Barbara just joined us. She is, I would say, prosecutor turned estate planning attorney. We're really happy to have her.
Thank you. Thank you. Happy to be here.
So far, she's just been, we haven't thrown her to the fire yet, thrown her the wolves yet. She's been just observing. And then let's bring Will to the stream as well. So, but do you want to tell us a little bit about yourself, Barbara? Tell the viewers.
Sure. So, as you stated, I have been a prosecutor for the majority of my career. I am excited to move into the civil realm and to practice real estate. Sorry, not real estate. Today is one of those days.
Yeah,
Probate and
yeah,
trusted estates law.
yeah. We deal with a lot of real estate, don't we?
We
We deal with
do.
real
We
estate
do.
issues.
We do. We deal with a lot of that. So
Uh,
I am excited. I mean, I really enjoy working with people, and of course, what to do and how to deal with assets after a person is gone. It's not.
oh, we kind of lost you. We lost your volume. Are you there, Will?
I am. I'm here. I can hear you. I've been listening.
Okay. Yeah, we lost Barbara. We're happy to have her. We've thrown her in fast, like typical style. We go quick. So she joined us Wednesday. Wednesday's our day where we have our team meeting, and then after the team meeting, we have our admin meeting. So that's where I say I play attorney. We go through all of our probate and trust administration cases. Not all of them. We just go through the ones that need attention right then.
Right.
And
yeah.
so we went through, I think, about probably 10 to 15 cases that day. I think you're back, Barbara.
Yay! Yes.
So, all right, good. So, yeah, so you've already seen a lot of different things, just kind of quickly, and a lot of different aspects of what we do. Some of the client meetings. I think you've seen some of the beginning meetings, some of the middle ones, and some of the end ones. I don't know if you've seen any of the end ones yet. That trust asset coordination session. Oh, we lost you again. It looks like you haven't seen it.
It's our typical Zoom meeting right here where some people are in and out.
Yeah, that's our lives now. So,
yeah,
all right, I'm gonna go ahead. I'm gonna share my screen. Oops. Yeah, let's add it there. All right. So welcome, Barbara. So last week was our show, the Live Pro Network is what we're calling it. That's where I bring on different guests and I'm doing my networking live with other professionals, opening it up so you guys can see it. Let us know who you'd like to see next, who else you'd like to have on the show. We got a lot of great guests scheduled. So next week we have Scott Fisher. This was last week, so you can go back 1 week and see our first show with attorney Ben Embry. He's a San Diego family law attorney, one of my good friends I've known since law school. So it was a great first show. And then next week is going to be Scott Fisher. He's from Options for Senior Living. This is a topic that comes up quite a bit. How to provide the care for your loved ones when they need those things. So excited to have him next week. So what I want to do today, the format of these shows. So we got a lot to talk about since we're switching every other week with a guest. It's kind of letting the topics stack up a little bit more. So what I want to do is review the questions from last week first, just briefly. or last week's topic was questions to ask your estate planning attorney. So I want to review that quickly. Then we'll get into today's topics, which are prenups and marriage plans, refi considerations. So if you're refinancing a house, a lot of people are doing it right now with the super low interest rates. So if your house is in trust, what you need to do there. And I'll give you a warning. I'm probably going to vent about my opinion of the attorney opinion letters. I think they're dumb, but so that'll be a fun topic. And then fixing bad trust, fixing bad irrevocable trust. Mm-hmm. So this has come up as well, recently since our last show. Really, all three of these topics are. So that's why we're talking about them today. So if there's, someone's passed away and the trust is irrevocable and you're going to administer it, what can you do? There's some cool things you can do. It's called decanting. So we'll get into that as the last topic of today. Replay. If there's any topics you'd like to see, let us know in the comments. So whether you're watching live or in the future, we'll check these comments and look for other topics that you want to hear about. Okay, so questions to ask your estate planning attorney. This is last week's topic. So, and do you go over these things with people, Will? Probably when you have initial conversations or phone calls.
Yeah, I get a lot of a variety of questions anyway, and some of them are pretty regular, but some can be unique. So I think that it's good to do those kind of things live so people can kind of get a sense of what to ask even before they come in.
Yeah, so I really enjoy these live streams where we have all the attorneys in the show, because it's kind of like our admin meetings. We can talk about these topics and get different perspectives on it. But before we get into the questions to ask your estate planning attorney, here's a question that already came up in front of Barbara. She saw how I answered it. Let's put Will on the spot. Let's ask him and say, so when people ask you this, Will, say, well, do I need an attorney? Do you get that question often? So a lot of times we'll tell them, we recommend you do recommending trust as a way to avoid probate.
Yeah, the answer is always it depends. I mean, most people, it's comforting to have an attorney explain things because you can print things off the internet or use firms that aren't lawyers, but then you may not get, you might not be doing what you truly want, and there might be problems or issues in there that could come back to hurt you in the future. And it's kind of the same answer for whatever area of law you're talking about. Lawyers aren't there to make your life worse. They're there to make your life better. And that's why we explain, and we go through a 3-meeting process as part of what we do to help explain exactly what every form is doing and make sure it's in accordance with clients' wishes.
Yeah, great. So I love how you answered that. You explain what we offer, and it depends. So the answer, I think we're all in agreement, is we're not going to say that yes, you need a lawyer for everything. I think that's kind of the old school mentality. Another way that old school mentality is shown is the length of documents. So this is something Barbara saw already. There's a case that I'm reviewing where there's a person who's a beneficiary in a trust. So his parents passed away. There's another law firm that's handling the administration, a big Phoenix law firm with very big, thick documents that I think are unnecessary. So it's literally, so we put an extra art binder, Barbara. So honestly, how much thicker, how much more paper would you say was in?
It was at least 5 to 10 times bigger than
art. Yeah, 5 to 10 times.
Yeah,
not even exaggerating. So, and a lot of that stuff is, our documents are still better, because they contain digital asset planning. So they were still missing some things, and they contain a lot of filler. So, but part of that is mentality. So some of that was done trying to create the need for attorneys. Like, this is hard, you need us. So one of our core values is empowerment. So we believe in, empowering the public, making it easy for them, and showing how they can hire us, and then they can choose to hire us if they want. So I think that's good to start that expectation. So here's the question that you should ask. One, do you have experience with probate and administering trust after the trust creator passes away? So in our meeting yesterday, our admin meeting, we saw some bad trust, didn't we, Barbara?
Oh, yes.
Luckily we didn't create those. So luckily they weren't ours. But we're stuck with them after they passed away. We'll get into our last topic. We can get creative. There's different ways we can solve it, but that's our blueprint. That's what we have to start with. And if you're starting with something bad, what was some of the bad stuff that we saw yesterday? The two charities. Remember that? It was just kind of like the trustee's option.
Yeah.
Yes.
And it was vague. It was written vague, where it could have been interpreted two different ways.
So, yeah, it said, they listed two different charities. It listed a percentage to 20%. Go to two different charities at the trustee's discretion. So it's like, what does that mean? And it means that I think how we interpreted it, luckily in this situation, one of the charities is no longer in existence. So that kind of helped us come to an agreement on how to administer this. But we think the way to interpret that language is that the trustee could decide how much to give to either one of those charities. So I'm glad one of them is gone, because how would we choose? How would we choose who, how much they get? We're opening up to a lawsuit from the other charity.
Yeah.
Mm-hmm.
So another thing we brought up in our meeting, we told Barbara this. This is kind of a surprise to people sometimes. Charities are the hardest beneficiaries to deal with. They can be the most difficult beneficiaries. Mm-hmm. So, and why is that, Barbara? You quickly saw and quickly agreed, but why is that?
Well, I mean, because oftentimes they have attorneys on staff, and of course, they're trying to, get the money in a certain way as well. So with that, it can be very persnickety when you're dealing with other attorneys and how that's going to be managed, basically.
Yeah, so exactly. And a lot of people, I think they, when they're creating their plans, they think, oh, these charities will be just so happy to get it. They'll figure it out. They can each figure out how much money and how to divide it and just play nicely. But, experience says different. All right. Second thing to ask your attorney, what does good customer service mean to you? So I like asking this one. And these questions come from, we have a little brochure. And this is kind of my script when we have an initial consultation, and they're like, well, why should I hire your firm? What's different between you and anyone else? And if they're shopping for prices, I think this is where it highlights this area. And I like what you said earlier, Will. What are they looking for? You talked about what we can provide, and if they want the lowest price, they can even get it free online. There's a lot of options now to get things free online or at super discounted. But what are they looking for in service? And we'll explain our process is 3 different meetings. It's actually 4 different meetings, 3 of them with an attorney and 1 signing meeting. So we're helping you through the process. Mm-hmm. Okay. Do you include a plan for digital assets and information that is stored electronically? That's a distinction between us, our Mott Legal brand of estate planning. We have a very good 3-part plan. Do you provide a way to access original documents online? And do you set aside time to help fund the trust? What does that mean to fund the trust, Barbara?
So when you are funding the trust, you are basically putting assets into the trust, basically, correct?
Yeah. No one knows what this means. So that's why I like your
you're putting the assets into the trust. There's nothing
what's a
there.
good way
to
say this? I feel like funding the trust is kind of like attorney lingo that people are like, huh? Funded? So when we create the trust, I think of it as an empty bucket.
Mm-hmm.
So we're creating a space that can hold assets or that can be named as a beneficiary on retirement accounts and life insurance accounts. So we have a meeting dedicated to giving specific instructions. We write them down on the attorney funding recommendations, what you should do with each account. So we created that process because I saw a lot of people were missing that. So again, it goes back to doing the probate and the trust administration. I'm watching to see what are common things that triggers probate, and just people not understanding how to get things into their trust. So that's why we created an extra meeting to try to avoid that. All right, so let's get into today's topic, marriage plans. What is a marriage plan? Let's see if Will knows this. This is another one of those things that I made up, kind of our proprietary processes. So the difference between a marriage plan and just a prenup. So I'll give you a hint. There's a hint right there. So
the difference, is that what you're asking? What the difference is between a marriage plan and a prenup?
Yeah.
So you're saying like a marriage plan, you could keep separate assets separate without doing a prenuptial agreement, whereas a prenuptial agreement would you're consenting to come out of the default community property.
Yeah. So I'll skip ahead. So so marriage plan, we're focused on the success. It protects both parties. It includes a prenup. So a prenup is part of the marriage plan, but we go a little bit deeper. That we also do an estate plan, which protects if the relationship ends by death. So your relationship's going to end someday, guys. I hate to break it to you. We're all going to die, right? That's mortality rate, 100%. We all know that, right? Mm-hmm. So that's why we're estate planners. So in our business, we're usually dealing with this, right? Death, when relationships end upon death, and how to divide assets at that time. So it's a lot of the same issues of how to divide assets if the relationship ends in divorce. So when we do a marriage plan, I like to back up and say that we're focused on the success of the relationship. The reason to do this, why do you do, a prenup, a marital agreement? Some people, there's a stigma to them still. I'd say it's getting better, or there's less of a stigma now, but it still can put a strain on the relationship. So there's value to it. There's value to it by clarifying, putting in writing what the expectations are of each party. So that's what I like to focus on. Focus on, providing a plan that will allow the marriage to thrive and succeed, and where you've already discussed these financial issues, where you're in agreement of how they're going to be handled. And I like to say you negotiate that stuff while you're still in love, versus after the relationship's ended, attorneys get involved. If it's not clear, we can argue things whatever way that we're hired to. A lot of times, if it's unclear and you're just getting one side of the story from your client, then that's what it looks like. So the value that you get out of a marriage plan is you make the plan before that's going to protect both parties. Like what do we want going into this? If you're bringing assets into the relationship, what's the expectation of that? Now, what makes us good or equipped to do these marriage plans is we help a lot of blended families, don't we, Will?
Yeah.
What we call his and hers kids, his, hers, and ours. So, what's that?
I said that's a good way of putting it. His, hers, and ours. I haven't.
Yeah. Sometimes there's joint kids together, but that changes the dynamic.
Right, and it changes how we do our estate plan, because we may be trying to control and protect for prior children.
Yeah. Have you had some uncomfortable meeting with clients talking about those issues?
Yeah, I've had my fair share, and some of them, it's not awkward at all, but just needed to be discussed. And a lot of times,
There, Barbara. Uh-oh.
I'm here.
Oh, sorry, you froze a little bit. Okay, can you rewind a little bit, Will? I lost you. Might have been my internet signal dropping a little bit.
Yeah, I was just saying that I've definitely discussed this with clients, and sometimes clients have discussed it and they're very open and they know exactly what to do, but sometimes they come to the meetings and they haven't thought about it, and it does get a bit awkward, and you need to kind of explain the difference between different trusts and different ways to control for children from prior relationships. But sometimes, the current marriage doesn't like that so much, because then they don't get to keep control of those assets upon the death.
Yeah, that's right. You're balancing those different interests.
Yeah.
And man, not to stereotype, but mama bears, they really protect their little cubs sometimes, I would say.
They sure do.
And it can go both ways too, where sometimes they might have unrealistic expectations of what's going to happen to their assets. So so there's value in that though, right? The couples that actually go through the process and sort it out. It's not easy. I've had people where they just give up, I would say. They're not willing to either compromise or come to a realistic expectation, so they just don't do it at all.
And then probably worse.
Exactly, because then it just gets worse and worse. So when we're dealing with that at the estate planning issue or at the estate planning time, if they've already been living together and acquired assets together, or things like that, it's more difficult, I would say.
Yeah.
Because they might have some expectations of what they want to have happen. Going into a relationship is a great time, because we can, figure out how to protect both of them, both parties. Let's talk some what it means to protect the parties going into a relationship. So here's things I've seen where, what if one party is giving up their working years to go, instead of working, the other partner wants them to vacation with them. And that I've seen what we call lopsided estates, where one partner has acquired assets and says, you know what, I want to enjoy my life, vacation, and I want you to come with me and enjoy that. But the other party was like, okay, that's great, that sounds amazing, but what happens 5, 10, 20 years down the road, when if this ends and I don't have any money set aside because I've spent all that time, touring with you. So, real interest, right? For security.
Mm-hmm.
So what we did in that situation is in the premarital agreement, we said we determined what the spousal support would be based upon the length of the marriage. So just, again, negotiate it while they're still in love. Don't let lawyers get in there and interpret it later, how much it should be. Just come to a clear amount. So that way, if it does happen, they're each protected. So, can you think of other interests that parties need to be protected from? I guess you talked about their kids some. I guess protecting their assets for their family.
How property is passed on, based on, do you want it to pass in the way that the normal Arizona law does? If both of you all are owning a property together and one person dies, how do you want that to pass along? Is going to be something that you really need to think about.
Yeah. So like houses, a lot of times people will come to us when they've already purchased a house together, or maybe one party has used their funds to purchase it. And they say, what should we do? And this is a lot of, we're seeing multi-generation houses. So parents living with their kids where they each have purchased it, or siblings, people that, they don't want to live alone. and they don't want to be renters. So they team up with a family member and purchase a property. So they don't get married, but it's a lot of the same issues. So for those people, we'll do what's called a cohabitation agreement, which is very similar to a premarital agreement, but it's setting expectations and deciding what's going to happen there. Okay, so what do we need to do a marriage plan requirement? Time. Time is the main thing. Give us some time, people. So come see us before you get engaged. Yeah, come talk to us before then. And we can't you can't send the prenup the day before the wedding, the week before. How much time would you say, Will? How much time do we need?
Oh boy, I think this would go longer than our typical estate planning process, and we'd need the couples to come in and sign and review. So at least a couple months, I would imagine.
Yeah. Now, I went to law school in California, so they talk about the Bonds Amendments, named after Barry Bonds, because it's what changed.
Uh-oh, did we just have Rilus get frozen?
I think he did get frozen for a second.
There we go.
Now he's back.
Can you hear me now?
Yeah.
Yes.
I'm back. That's my test. I shake my head. If my head's wobbling, we're live. Otherwise, we're frozen. So the Bonds Amendments is kind of what set the standard for a valid premarital agreement. So basically, Barry Bonds, his first wife, or I don't know if his first, or I don't think it's his current one, but English wasn't her native language, and I think the wedding was in Vegas, and he had the limo driver stop by his lawyer's office. Here, sign this on the way. Plane's waiting. Everyone's waiting in Vegas.
Unconscionable.
Yeah. So that's obviously too short, right?
Yeah.
But actually, it held up, and that's why California, they changed the law after. It held up the first time. Really? That's what's known as the Bond Amendments. They're like, wow, that's messed up. We gotta change that. So you need enough time. It's got to be in their native language, and each party has to understand it. So the only way to prove that is that each party is represented by counsel. Because if the other party is not represented, they could always say later, I didn't understand what I was signing.
Yeah.
Right. And case law has shown that could be a valid argument, that they could, get out of the marital agreement if they didn't understand it. So we need an attorney for each party. Mm-hmm. And here's something I learned, a lesson I learned. We were doing a marital agreement, and I was required the other party, but we didn't have a hard and fast signing date. And in this situation, we were already kind of pressed for time. By the time I met with them about the marriage plan, the wedding was already scheduled in like 2 months. So they already had the wedding was scheduled, but before that, they had a rehearsal dinner, things like that. So what happened is we started getting down like a week before the wedding. We had a date for to sign the agreement, and it didn't happen. She just didn't show up. And then her attorneys, they just went silent. And I think it's actually genius. Now it's all by design, but they didn't sign it is what happened. Rehearsal dinner happened, started going through all the motions that they, were already in place. People were already coming into town, and it just didn't get signed. So
a premarital agreement become a post-nuptial agreement, but they still need to sign it.
Right.
Post-nupts are worthless, basically. Case law has shown that post-nupts do not hold up because there's no consideration.
Right.
Because marital agreements, it's in consideration of marriage. The parties come together, in considering getting married together. So it didn't get signed. And I'd say that I think that was the move all along, that they didn't intend to sign it. So what I would say for a marriage plan is you need to schedule a hard and fast signing date. And if that date passes and it doesn't get signed, then there you go. Treat it as they are not willing to enter into the marital agreement. And then you got to ask yourself, I guess this kind of goes in, I'm probably not the best person. I'm a divorced, and single, but you need to ask these questions, early on. You need to have that conversation early, and what if the party doesn't want to sign it? Are you going to go into the relationship anyways, or you got to have, I think, a hard and fast time where you make that decision, and that's done by scheduling a signing date. And I'd say we're talking about in the office. I was saying treat it like a drug test. Like if you're scheduled for a drug test and you don't show up, then it's a failed drug test. So same result. So I'd say let's schedule a hard and fast signing date, and then if it doesn't happen by then there you go. Then don't plan the wedding. That needs to be before everyone has notice and the plane tickets are booked and the flowers are bought and all of those things. So, okay, you want to say anything else about marriage plans before we go on to the next topic?
I think you covered it all.
So, all right, potential rant. So this is something that comes up a lot. So when people are refinancing their house, they give all their information to the title company, and the title company will say, okay, we want an attorney opinion letter. And what I guess the people are like, well, what's the big deal? Why don't you do it? Well, we're a business, right? We like getting paid. I mean, we have to get paid to survive as a business. That's how it works. So we work with flat fees as much as possible on our estate planning end, and we have competitive fees, and we don't have the time built in there to write extra letters for every client. So although I would love to do these things, I haven't been very active. My Instagram people, you haven't seen me do my chair post or anything. So it's been, working like crazy lately. And even like during lunch, I had people calling me, hey, can you help with this? Can you just write a letter? It's like, I'm just trying to eat a taco in before I got to go to the next thing. Like I would love to do all of these things, but we just, we don't have the time to do it. So, I've done some of these attorney opinion letters in the past, and they're just stupid. In the past, I'm saying it's been a long time. I haven't done them for 5-7 years plus because I think they're a waste of time. But they ask us to state the same things that are in the trust. And we had one recently. They want us to do a letter that the trust was not revoked. They had a copy of it from the client who created it. The parties of the trustor and the trustee, but yet they wanted a letter from an attorney saying that it was still valid. Why? Why do we need to do that? Why? What does it do? And again, if we do the letters quickly for the title companies, they usually come back, and it takes more of our time because they'll ask who the trustors are, or who the settlors are, when it's actually the same thing, or they just want us to do their work for them is what it feels like. So what we recommend is just remove the property from the trust, and you can ask the title company. A lot of the times they'll do this for you. You just got to make sure you put the property back in after the refi is complete. So, and I guess this all depends on the title company. I ask a lot of mortgage brokers about this. And I'm saying, it's such a pain. I hate that they want us to do their work for them. And some title companies will just, as part of the refi, they'll move it out of the trust. And then after it's over, they'll put the property back in the trust. And, what I told the person the other day, I feel bad telling this to our clients. And I just don't know what the expectation is from the title company. If they're saying, go to your attorney and get this letter, if they're requiring that, then I think that they should pay for it, right? Or at least should be built in. There should be some consideration for those costs. Have you had this issue come up, Will? These attorney opinion letters?
Oh yeah. Well, not so much the letters. The majority of the time, the title companies have taken title out of the trust, and the clients are wanting us to put it back in. I just think that we should, we should be, yes, compensated for our time, but also for the liability. Writing an attorney opinion letter is kind of us guaranteeing what we say in that letter. And so they have to be very carefully worded, and we need to kind of research, which takes time. And then why would we take on that extra liability for no compensation from the title company or the client for the most part? Because they seem to think we could do this in like 5 seconds over taco or something.
Yeah. So, yeah, exactly. So by signing a letter, we're taking on the liability. So we have to, actually read it and see exactly what they're wanting us to say, and make sure they haven't slipped anything in there.
Yeah.
Here's another thing. I'll talk to the other attorneys about this. People don't feel bad for attorneys at all, do they? If they slip something in the contract and we write an attorney opinion letter, we can't say, "Oh, I didn't read it. I didn't understand it."
Mm-hmm.
Yeah. So, and people do that too. See if you can sneak this past an attorney is kind of a tactic. If you can get some attorney to sign off on this, then
yeah,
basically it's their liability.
Mm-hmm.
So yeah, if you're refinancing a house, we'd love to help you out as much as possible. If you can give us some time on that, that helps, and we can do the deeds for you for our minimum fee, which is $350. That's actually cheaper than what we would do an attorney opinion letter for, and I just won't do one. But so for $350, our minimum fee, we'll do 2 deeds where you transfer it out of the trust and back in. So you can do your refi, you transfer it out, do the refi. After it's complete, we'll record the deed that puts it back in the trust. So we want to make sure we're providing options for people. I don't want to just complain and say what we're not going to do.
Yeah.
I always want to help and say what they can do. And the quickest way to the finish line if someone's in the process of a refi is put it back on the title company, right? They can do it. They have attorneys on staff. They're actually being paid in this transaction. So make them do the work. And I don't think it's, if they're asking you for, to see an attorney, either that expectation should be set from the beginning, like, hey, you're going to have to incur this expense, or they should incur the expense for them. So in our new world, I think you're going to be seeing more of that. It used to be that legal fees were so high and attorneys were charging so much, they could do little things like this for their clients. But that's the people that were, confusing them and making sure that they'd have to come back and see them often and pay them a lot every time. All right, so providing a copy of the trust should suffice. By giving the actual legal documents, that should be everything that they need. All right, this has been one of our longer live streams. There's been a lot of topics. I've been excited to do this. Excited to talk about. All right, last topic for today: fixing bad irrevocable trust. So this came up briefly. Did this come up in our admin meeting the other day? I think
it might have. It hasn't.
Yeah.
I was talking to people about it this week, but before Barbara started on Wednesday, I had a call about this. So here's what I'm speaking to right now. So if you're a beneficiary of a trust, if someone's passed away and you're entitled to receive something from a trust, we have some really cool options that we can do to get better results. We can't change the beneficiaries. If you're upset that your brother that you hate still gets something, we can't change that, but we can create intended results of the trust creator. Now, some common examples of that is to create a supplemental needs trust, or also known as a special needs trust. So if you have a beneficiary who's receiving governmental benefits, whether that's Medicaid or Medi-Cal or All-Tex or anything that's, I don't know if those are income-based, all of those, but any income-based programs, if they receive money, if they receive money in their bank account, they could be disqualified from those programs. And sometimes they also get disqualified from insurance. And, so their inheritance would have, the way the system's designed is they would use the money they inherited to pay for those expenses. And then they have to re-qualify again once they run out of money. So that can be really devastating considering, how long does it take people to qualify for disability sometimes? I think multiple years.
Years.
So we've seen situations where people are going to, inherit money that would last for only a matter of months. And then it's going to take them years to reapply again is a concern. So that's the real concern. So, we can add a supplemental needs trust, and we've decanted that way for that reason. And here's another option, which it can be done. I put a little asterisk on there because it may be tainted a little bit, and this is kind of getting into some advanced planning. But we can add a dynasty trust in there. So what is a dynasty trust, Will?
Right. So a dynasty trust is kind of like a sub-trust so that, for instance, when your kids turn a certain age, the trustee could switch to them, and that way they're
the connection.
Did you lose me?
See. Yeah, we lost you. Can you start over again? What is a dynasty trust?
Yeah, sure. So it's a sub-trust. So a sub-trust where instead of just giving the money to the children outright, at that point, they could become the trustee of their own trust. That way the assets don't actually become theirs until they essentially give it to themselves out of that trust. So it's something that can kind of live forever that way.
Yeah, so the assets don't become theirs. I like how you said it that way. So they're protected from the estate tax in the future. So when they get transferred to the next generation, they don't have to pay an estate tax on them. So it's technically called a generation skipping trust.
Yeah.
So, but we talked about the Fight Club. Is how I like to bring it up. First rule of Fight Club. What's the first rule of Fight Club, Barbara?
Don't talk about the Fight Club. There is none.
So that's the first rule of asset protection too. First rule of asset protection is we don't talk about it. We do tax planning. We do estate planning. So, but a nice coincidence of tax planning is if they're not going to be subject to the estate tax again, they're also out of reach of creditors. So it's possible that we can also amend or decant an irrevocable trust to include a dynasty trust. And I put a little star on there just to make the other attorneys happy. It may be tainted a little bit. I don't know if there's case law about this yet, but I believe it can be done. Mm-hmm. And I think the best protection you can get is if your parents actually created that dynasty trust for you. But if they passed away and you're in the process of administering, this is the next best thing you can do. Once you actually receive the money, then you can do like a Nevada onshore trust or asset protection trust in different jurisdictions. But I still think this would be better. The dynasty trust created by your parents, even if it's a little, I'll call it tainted. Maybe tainted's not the right word, but untested. So what I want to emphasize is each situation is different, and this is getting into more advanced estate planning, and requires attorneys to make recommendations with little precedent. So by little precedent, I mean California's only had this law since 2019. It's only been a law in California since then, January 1, 2019. Arizona, we've had this since 2011. So I'll tell you a little lesson I learned. I said, so we had a case where it was a California trust. This was in 2019, towards the beginning of 2019 too. And someone came to us and they said, hey, we got a crappy trust. It was amended like 7 different times. And one of those amendments created a special needs trust for her brother. But in the 7th or 8th amendment, it didn't. Or basically the trust was never funded the way they designed the plan. And they said, so the California lawyers actually said, see if there's a way. They asked the people to see if they can find out a way where we can get it inside of a special needs trust. So I met this lady in Scottsdale, Arizona, who was a beneficiary of the California trust. And I was like, yeah, actually we can. And good news, California can now do this. We've been doing it in Arizona for a while. And so I thought I could convince that other attorney in California to just, use the new law. And, after a year, over a year trying to get him to, I was telling Lori, our paralegal, I was like, dang, it's like, I didn't realize how hard it would be to get an attorney to do something. And she had a good laugh. It's like, I could have told you that.
He was uncomfortable because it's untested. Yeah.
Mm-hmm.
Yeah. And this is, there's a lot of things I want to do, but interest of time I can't. I thought it was a breach of the duty of competence of being an attorney and not doing that for his clients.
Mm-hmm.
And, if you're going to practice law, and that might have been like a California specialist too.
Mm.
And I was like, I heard about this. Like, I don't think he was a specialist, but I was like, are you a member of the trust and estate section of the bar? He's like, no. I was like, well, you probably should be, because they had a article on this on the cover, and it's been everywhere for months, like this issue. But yeah, he wasn't willing. So the attorney represented the CPA, who was the trustee. So yeah, the CPA was like, they weren't willing to follow the law, is what kind of bugs me. They weren't willing to practice law. They just want to do what everyone's always done. So,
yeah.
So we've had it in Arizona since 2011. I say the OGs before that. So the OGs, older attorneys in New York, a guy named Jonathan Blotmacher, who's kind of developed a lot of strategies, represented a lot of famous people. I think like Jackie Onassis, those types of estates. Very creative attorney, but so they were doing this before there was even a statute, and that's what created the law. But it's based on a theory that the trustee that has discretion over the principal in the trust, that by using that discretion, they can also amend the trust. So that was kind of the angle in. And the reason it came about, that Arizona passed the law in 2011 and other states that started passing the law, there's a lot of bad irrevocable trust out there. Particularly, I see a lot of bad ILITs. Have you heard of an ILIT? Irrevocable life insurance trust? So we don't see many of them anymore. But when the exemption against the estate tax was a lot lower, around 600,000 or $1 million, people would do an irrevocable trust, and it would hold life insurance, and the proceeds of the life insurance would be outside of their estate. It's kind of like a dynasty trust that you create during life, and then it gets funded with life insurance when you pass away, which is estate tax free, and that creates liquidity to pay the estate tax bill over like real estate and other assets that in your estate. So a lot of people created those. There's a lot of like insurance companies that sold insurance and created a trust with it. But I saw one where the trustees resigned. No one wanted to be the trustee of it anymore. So I'm actually the trustee of an ILIT, because I guess I kind of jumped on the grenade, so to speak. No one would take over it. So we ended up decanting the trust to name a beneficiary, or to name a trustee, because it didn't have any way to name a trustee. So the old way of doing it, you'd have to go to court, petition the court, ask the judge what to do. So the more official name of decanting is called, it's a way to non-judicially amend an irrevocable trust. So, but the courts have signed off on this and said, you know what, we know there's a lot of crappy trusts out there, So we need to have a way where attorneys can fix these problems, and we don't want to be, we can be bothered by all of these bad trusts that'll just weigh down the courts. So, all right, so that's decanting. So something to be aware of if you are a beneficiary in that situation, or if you see that come up, there are options, but you need a good attorney that's willing to actually practice law. It's not scared of their shadow, and can get out there. So thanks for tuning in. The next thing's coming up. Let's see, am I frozen on there? There we go. So next week, we'll be back for another live Pro Network show. We're gonna have Scott Fisher from Options for Senior Living. We're gonna be talking about options of if people need assisted living and different levels of care, what to do there. So something that comes up quite a bit. Thanks for tuning in, everyone. We'll see you next time.
Sounds good. All right. Thanks, Rilus. See you soon, Barbara. Take care.
Yeah.
Bye, everyone.